Guys, this case is already way past a normal guardianship fight. The court says mom knew exactly what she was ordered to do, yet the child still hasn't been turned over, and now mom isn't even standing in front of the judge.
English.
Matthew English.
Josh Goodday, Your Honor, present on behalf of Lauren Ryan.
Roy Flay, present, Your Honor, for the petitioners.
Okay. And I am not seeing either parent. So with that, this was I did receive the declaration petitioner in support of sanctions for respondent. Again, going back, and there had been a show cause for contempt. I had set it over essentially to see where things were when, or I signed the order with the additional language in some terms, but understanding that additional requests could be made based on what occurred. I did read the declaration of what did or did not occur as it may be. So Mr. Flay, anything else you wanted to add to that?
Your Honor, we also wanted to request, because last hearing actually was a review hearing for the minor guardianship at large, not just the emergency guardianship. So we still need to have an actual temporary order issued in the general minor guardianship. This is important that we have, a temporary custody order that has a deadline beyond just a week. We've been doing all these hearings where there's, short-term emergency orders granted. I don't think any of us anticipated emergency minor guardianship going on, about 4 months now. So we would request that, a temporary order be put in place reflecting the Englishes as the minor guardians in the general minor guardianship. I think in order for us to move anything forward as well in California, the courts down there need a certified copy of something showing that they are the minor guardians, in fact, for a set period of time that's not just indefinite or a week. So I think it's very important, because originally last week's hearing was scheduled just to be a review hearing, turned into a contempt motion based on recent actions of the respondent. So we just want to make sure that's revisited.
Okay. All right. Did you happen to submit any proposed order reflecting any of that, Mr. Flay?
Your Honor, we did when we first filed the initial case. I understand that, probably that's not in the bench copies, obviously. So we're more than happy to submit one via email today or whatever method's preferred. But we just prepared essentially for what was ordered from last hearing, and at no one's fault. I think it just wasn't discussed last time. So whatever method you prefer, Your Honor, we can prepare it.
When you filed the proposed, when did you file that? Do you know?
Everything for the initial minor guardianship would have been back in late September. So I don't know if you'd even would have received a bench copy. This was also multiple different judges ago. And again, it's a proposed order, so the bench copies wouldn't have necessarily been filed with the court.
Right, and I understand that. I'm just trying to pull up what you're proposing as an order so I can make sure there's no issue with it, but I'm not. Let's see. This petition was filed in October of 23. Okay. Well, I'll come back to that. Mr. Goodday?
I have a few things, Your Honor. So my client texted me this morning. She's asking for a new attorney in the case. I feel there are she doesn't have any confidence or trust in me. I feel there's a breakdown in our communication. Could be irreconcilable differences. She also wanted the court to report a GAL and do a full investigation on the case before ordering Emma to be turned over to the petitioners.
Anything else?
No, Your Honor.
Mr. Flay, anything?
Well, Your Honor, we would ask that Mr. Gooday not be excused from the case. I don't know what correspondence that has been reflected between them, but at this point, any correspondence dealing directly with Ms. Ryan has proven to only be very difficult, if any at all. So, you know, we're very appreciative Mr. Gooday's on the case. It makes things a lot easier to work with this juncture, but I don't see a reason for him to be dismissed unless we see something filed showing that correspondence. And then regarding the guardian ad litem, Your Honor, I believe we asked for a guardian ad litem initially in our petition anyway, so we're in no opposition to guardian ad litem being appointed. However, I think Ms. Ryan's motive for that is to show that the Englishes are not fit, or I'm not really sure what her strategy is there, but a guardian ad litem can be appointed and my clients still be guardians at the same time. They can do a report with Emma in the English's care. Moreover, we're still dealing with the situation where Emma's not in their care. So the person asking for a guardian ad litem has been adamantly disregarding the court orders since October. I don't think it's fair that the court should grant their wishes for the purpose of, questioning my client's ability to be guardians when they haven't even been able to do that yet. So, we're standing by our position and our contempt requests. We think jail time's appropriate. All the sanctions that listed are appropriate, and all the financial compensation that we've requested in the money judgment is also appropriate. Thank you, Your Honor.
So in regard to the mother's request regarding Mr. Gooday, I'm not hearing one, she's not even present. She hasn't been present. She hasn't.
This is where the petitioner's strategy becomes much bigger than winning another short-term order. Their attorney is trying to turn temporary courtroom authority into something usable outside Washington.
Respondent, we're in the middle of contempt actions, and it would not be appropriate at this point to leave her without an attorney when we're looking at the idea of a warrant for her arrest and jail time. So at this point, I will not be removing Mr. Gooday as the attorney. As far as the guardian ad litem, at some point, we will get to that. Right now, the focus is on her complying with a court order, and that still hasn't occurred. So, Mr. Gooday, I don't know if you have any response in regard to that matter.
I did some research, Your Honor, and I did accept service, but Miss Ryan was not personally served. So my understanding is that jail time could not be ordered due to that. That's just based on my research and speaking with other attorneys. So I'll defer to the court if that's true or not. But
and Your Honor, can we
otherwise we're
respond
still
to
in the
that?
same situation.
Mr. Flay?
We've asked numerous times, where is Miss Ryan? Where's Emma Ryan? We don't get an answer. We have no idea where Miss Ryan is. The only course of action we have is to serve Mr. Gooday. Again, it seems Miss Ryan wants to play by her own rules and then fall back on technical procedural rules when the issue is even possible. So I think it's more than reasonable. We could have attempted personal service if we knew where she was. We had to stake her out initially in this case to even serve her at a courthouse when she was dodging service at the women's shelter. So I think it's more than clear that, if Miss Ryan really wanted to be served, or if that was the issue at hand, she would have still gone above and beyond to avoid service. So I would object to Mr. Gooday's request for it to be denied.
I'm concerned, and I understand where Mr. Flay is at, and I also understand what Mr. Gooday has indicated. My concern is that she's intentionally hiding from service. So at this point, the fact that she is in contact with her attorney, and that she at least knows enough of what she's doing to make the request that she's making, then the court sees that she has knowledge of what's going on and is intentionally evading the service of the guardians or the emergency guardians. So my question is, Mr. Flay, at this time, with all that, do you have any legal basis when personal service has not been made on the mother to issue a warrant? And I'm not saying there isn't, but it's not an issue I've dealt with for a while.
And Your Honor, I would have to research and do a memorandum to the court on that. But in my experience, under Judge Warning and others, this has been an issue that didn't seem to bar from that being a warrant being issued. So again, I'm concerned, I think we've exhausted all remedies in attempting to find her, and her refusal to show herself would bypass, the ordinary procedure there. I would have to, again, write a memorandum to the court, which again is buying Ms. Ryan more time, which is very concerning because we do not know the whereabouts of Emma. So I think it's an exigent circumstance that we need to, do something. I think also it's important that Ms. Ryan be ordered to appear in court, because if we are to issue a warrant, we need to, make sure that it can be acted on. But I guess for safety purposes, mostly it just seems strategic to have a warrant out in case, Lauren is in a situation where she runs into police, and then we can find Emma that way. Again, but I would have to do research on that, and that would buy us more time and cost my clients more legal fees to get that done. So, because we haven't, obviously, most of us have not dealt with a circumstance like this. So it's highly unique and needs to be researched thoroughly before I can give an answer, legally speaking.
Yeah, I just want to make sure that we're on good ground. I'm not necessarily opposed to it. I just want to make sure that I'm in good standing to do so. So I'm going to take a few minutes and I want to go look up something, and I will be back. Recalling the guardianship of Emma Ryan, 23-4-00364-08. All right, I've had an opportunity to process and think a little bit more about this. And first off, I am aware that the mother had full knowledge and directly told that she was to turn the child over, that she has intentionally failed to turn the child over, that she has hidden herself and hidden the child from turning the child over as ordered by this court. This matter was on last week. At that time, a request was made for a warrant, and I set the matter over 1 week.
This is the procedural obstacle that can completely change how aggressively a judge moves. The mother's attorney raises personal service, and importantly, he doesn't pretend the answer is settled.
For the opportunity for the child to again be turned over before issuing any warrant. It is clear from what I'm hearing that the mother has been in contact with her attorney. It was the attorney that was served with the show cause hearing, that the mother clearly knows about the show cause hearing and the request for contempt, including the warrant for arrest. That for all purposes, she has full knowledge of the request to find her in contempt and the sanctions that are being requested, that she has, and again, intentionally avoided the order of the court that has been made with, again, full knowledge of what she is supposed to do. For that reason, I will find that she is in contempt, that the mother has intentionally, again, avoided and failed to follow the order of the court. And that there appears to be absolutely no way to get her to appear before this court without a warrant for her arrest. That she can purge that by appearing next Thursday at 10:30 a.m. at the Cowlitz County Superior Court, Courtroom 3, second floor, and appear with the child to answer. If she fails to do so, the warrant will remain out. That said, anything further in regard to the penalties, fees, and costs and expenses?
I thought this folder.
Your Honor, just what we just asked for what we requested. Again, we filed all the travel expenses that my clients incurred this past week. I think our order said 1,000, Your Honor. I believe last hearing you said it would be $250 of the 1,000 from sanctions. And then today, I think correctly, we should be asking for $750.
Right.
And then 5,000 in attorney's fees.
Mr. Gooday? White out? By chance? White out?
Nothing on that, Your Honor. I just wanted to clarify about the warrant. You said she can purge it by appearing next Thursday.
Right, and so to clarify further, the warrant will not go out until, so I'm gonna set it on for Thursday for her to appear with the child on that day, and that she will turn the child over to the English or the petitioners. And so the warrant actually won't issue until after next Thursday's docket.
So that's next Thursday in person, courtroom 3.
Right, 10:30 a.m.
All right, thank you.
So I'm modifying the proposed order and putting for the civil penalties 750 because last week I did order 250 based on the intentional actions of the mother and the time that it's been taken or been taking. I am going to order $5,000 in attorney fees and costs, that an additional $2,644.06 for travel expenses based on the documentation that was shown for the petitioners to travel again to California to try to pick up the child. Let's see. I adopt the otherwise I adopt the proposed contempt hearing order. And the court does find that the mother was able but not willing to follow the order of this court. Next Thursday is the 18th. And then under paragraph 10, jail time, I put reserved until January 18, 2024 to give the mother the opportunity to appear in person with the child at 10:30 a.m. courtroom 3. If fails to do so, this paragraph applies.
Your Honor, so you're indicating that you will impose the jail time on top of the warrant if she doesn't appear Thursday?
If she doesn't appear, the warrant will issue and she'll be jailed until she turns the child over.
Understood.
No, I think I probably should have written this differently. All right, so I'm going to rewrite this a little bit. So on paragraph 1, I changed civil penalty to 750. The other remains. Paragraph 3 is adopted. There's supposed to be a paragraph 4 because I'm not seeing it.
Your Honor, I think that would have been,
Other findings?
yes, I think after the emergency guardianship order was not obeyed, there's the ability to follow orders bad faith. I think it should be there. Your Honor, I think I've realized the issue. The section, the number I think just got moved because we didn't use section 3, which is supposed to be for support payment issues. There were no support payment issues, so that was omitted. But that was just accidentally taken out. But
I made other findings, paragraph 4, and I'm putting the mother is represented by an attorney and it's clear she has full knowledge of the show cause hearing on contempt and has intentionally avoided.
The analysis becomes much more focused on knowledge and intentional conduct. That's significant because the judge is building a record, not merely expressing dissatisfaction. She identifies what the mother allegedly knew, the opportunity previously provided, her contact with counsel, and her awareness of the pending contempt request.
I put, again, the mother's represented by an attorney. It's clear she has full knowledge of the show cause hearing on contempt and has intentionally avoided appearance before the court and is hiding, as well as hiding the child. Okay, so what I've added under jail time says once a minor child, Emma Ryan, is immediately surrendered to the petitioner's emergency guardians by January 1824 at 10:30 a.m. Courtroom 3 of the Hall of Justice, 312 Southwest First Avenue, Kelso, Washington, 98626. If fails to do so, a warrant for her arrest shall be issued. The court will review compliance with these conditions at the review hearing set in section 12 below. So I'm going to put January 18, 24 at 10:30 a.m. Minor guardianship docket. Does that work, counsel?
that should be fine, Your Honor. I'm assuming the rest of the parties still may appear via Zoom.
Right.
Besides Englishes, they'll need to be there for
They'll need
transfer.
to be there for the child, correct?
And then I think that's everything for the contempt order. I was just hoping we could revisit the minor guardianship temporary order.
Okay, just a second. So in regard to this, Mr. Gooday,
In regard to your order, Your Honor?
yeah, are you okay to put a approved as to form via Zoom?
Yes, Your Honor.
Okay. All right, so the other counsel. Go ahead on that.
Thank you, Your Honor. Just basically reiterating our previous points on the temporary order for minor guardian or the general minor guardianship. We don't have a proposed order sent with those bench copies. However, we're happy to get one over as soon as possible. But the concern is that the attorney for the Englishes in California wishes to file a petition for a habeas corpus to find the child, and they need more than just the weekly orders that we've had listing how long the guardianship is for. So we'd be asking the court to order on a temporary basis for the general minor guardianship that Brooke and Matthew English are the guardians under that order. Again, we need to submit that so we can email that if that's allowed, to get it into you as fast as possible. But at this point, we've been well beyond the emergency minor guardianship timeline given the circumstances, but we haven't had any review hearings on the general minor guardianship yet. So we're hoping to get an order to reflect that so they can move forward with having something to be able to find Emma possibly in the state of California.
Mr. Gooday?
Your Honor, I would think on a general minor guardianship, my client would have the right to a hearing. Versus just the temporary emergency.
Well, To clarify, Your Honor, the last two hearings technically were review hearings for the general minor guardianship that were set a month prior. The fourth hearing, in fact, was set by, I believe, Judge Warning originally to be a review of the minor guardianship. Unfortunately, the contempt became a much more pressing matter, but the court never actually reviewed it. So we're hoping to get a review of that today, but that was the court's intention when that review hearing was set. So I think the opposing party has had sufficient notice and knew that this hearing was coming. Whether she understands that or cares about that, that's besides the point. So.
Mr. Gooday?
I would just request if we're gonna do a general guardianship that there be the full hearing with the guardian ad litem.
And Your Honor, if the court doesn't want to move forward today, we'd at least ask for an official order extending the emergency minor guardianship, something to show other courts in other states that there is a set time that Brooke and Matthew English are the minor guardians for Mariah. But currently things are moving so quickly with this case, we haven't really had, or at least sparingly had, orders to say so. So we'd be asking at least for something extending the emergency minor guardianship at the very least, and then, a review on the general minor guardianship as the court had originally set for these hearings.
Mr. Gooday?
That sounds reasonable.
So the court would agree with that. I have a hard time doing the other. I agree that a guardian ad investigation needs to occur, and before we move into that, understand what you're needing and why you're needing it. I have no problem with the other order that you proposed on the emergency guardianship. So if you can get me that order, I can sign off on that. So if you could submit that to Mr. Gooday for review and then get that to me, I'll go ahead and accept. Typically, I won't accept email orders. I want them in hard copy, but again, recognizing there are several things happening here, and the court is wanting to get this moving forward. So I will go ahead if you get that emailed to me.
Thank you, Your Honor. And just to clarify, are we setting a period of time for that to be lasting for 30 days?
30 days would be the appropriate time.
Okay.
The focus now shifts from punishment back to the larger guardianship structure, and that creates a different legal balancing act. The petitioners need an order strong enough to use in California, but the mother's attorney pushes back on moving from emergency authority into a broader guardianship without the fuller hearing he believes should accompany it.
Your Honor, if I may,
Go ahead.
this is Sherry Farr, guardian ad litem, and I would just like you to be aware that I have a conflict in this matter. I know that the court is short on guardian ad litem, people to serve as guardian ad litems. There was a previous investigation that I was appointed on involving one of the other children, and part of that agreement was that my report was sealed and I was prohibited from testifying any further. And so because of that, I don't believe it would be appropriate for me to serve in this case.
Okay, thank you for that information. I appreciate it. So counsel, if you would just keep that in mind when we get to the appointment of a guardian ad litem. Okay.
And Your Honor, to clarify, we're just reserving on the issue of guardian ad litem for today?
Correct.
Okay.
Yeah, and it has a lot to do with English, the temporary emergency guardians haven't had the child, and they're not going to get very far with the guardian ad litem at this point. I don't think if it continues like that, then we probably don't have any choice but to move forward. But at least that's my concern at this time. I think the guardian ad litem would want more information, and we just don't have it yet. Okay.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, counsel.
And so, Mr. Flagg, bring the guardian ad litem issue up again. the other thing that would be an issue is we're gonna have to find somebody. Because we're limited on who we even have available. And if the one that we usually have can't do it, then we're gonna have to find somebody else.
Your Honor, I imagine, I'm sorry if I'm speaking on a lot of hypothetical timelines here, but I imagine, after next week, the exchange would happen. I'd imagine we would be citing on some sort of review for the actual general minor guardianship. Should we be motioning for a guardian litem, or it was requested to be?
No, that's fine. You can just bring it up like you did.
Okay, thank you, Your Honor.
Yeah, and I think Mr. Gooday was wanting it as well. His client was wanting it too.
Okay.
Okay. All right, so I'll sign off on the contempt order. Get me the other order. We'll set it over 1 week for the mother to appear with the child, or a warrant will be issued and she'll be facing jail time. And then in regard to the guardian litem, let's just bring that up in 1 week. Let me give staff an opportunity to see who they can get, because just rethinking it here that we probably need to get that moving forward no matter what. And so let's go ahead and put the guardian litem part on too.
The case has apparently remained in emergency territory far longer than anyone expected, yet the underlying dispute still hasn't received the complete review normally associated with a longer-term arrangement. The petitioners emphasize notice and repeated review settings. The defense emphasizes process and investigation. Neither concern disappears simply because the case is urgent. That leaves the judge searching for a middle position. Preserve workable authority now without prematurely deciding the larger guardianship question before the record is sufficiently developed. The judge's compromise is revealing because she gives the petitioners practical help without granting everything they requested. Extending the emergency guardianship for a defined period creates documentation they can potentially use while preserving the bigger guardianship decision for fuller review. That's a meaningful power balance. The court is moving the case forward, but it isn't allowing urgency to swallow process. Then another complication appears. The available guardian ad litem identifies a prior involvement that creates a conflict. Her decision to flag it matters because an independent investigator only helps if everyone can trust the independence of that investigation. The judge doesn't force the appointment simply because resources are limited. There's another practical problem too. An investigator can only evaluate so much when the temporary guardians haven't actually had the child in their care. That limitation keeps the court from pretending it has evidence it doesn't yet possess. By the end, the court is trying to build several tracks at once: immediate compliance, continued emergency authority, and an independent investigation that may become necessary regardless of what happens next. That's a major shift from simply waiting for cooperation. Staff may need to locate another guardian ad litem, the emergency order needs formalization, and the next hearing becomes a concrete decision point rather than another open-ended review. What matters most is that the judge has narrowed the uncertainty. There's now a specific obligation and a defined consequence attached to the next appearance. The closing commentary predicts the mother won't arrive with the child, but that remains the commentator's prediction, not evidence. The court itself leaves the door open for compliance. And that distinction is important because the next development has to be judged by what actually happens, not what anyone expects.